First of all, welcome to all of you, both virtually and in person. We are so thrilled to have you here today. Happy Pi Day to those who celebrate. And welcome to the first event co-sponsored by both the Coalition of Women's Initiatives in Law and Chicago Women in IP. This presentation was sort of born of both groups brainstorming independently what we really need in the DE&I space right now, and realizing that one of the things we need most is clarity. Like, especially in law firms, people are just very nervous about different initiatives, how they can proceed. And so both groups decided that it was really important to have a presentation like this so that we're all clear as we can be at least, on what's going on and what we can do to help our organizations and law firms proceed in the current environment. So before I get started with the substance of the presentation, I want to first let you all know that there's a CLE sign up here physically at the sign up table if you haven't had a chance to sign in. And when you leave, there will be evaluation forms. For those of you virtually, Mann and Burns should be posting in the chat the sign in and the CLE evaluation. So if you are here for CLE, in addition to the substance, please be sure that you sign in so that you can get credit. Also, we encourage all of you to ask questions. We will be saving them until after the panel, but please, if you think of questions, feel free to put them in the chat as you go or hold them in your mind here in the room, and Grayson will open up the floor. We have reserved time at the end for a Q&A. And then also, if you're here, please do feel free to stay for a short reception afterwards. McAndrews has been kind enough to provide some nice beverages and food, so I encourage all of you to stay, get to know each other a little better, and if you happen to be a member of one organization and not the other, find someone from the other organization and meet them and find out how great both of these groups are. Also, before we start, thanks to McAndrews, who happens to be a member of both organizations. We're so grateful for them hosting today, and especially grateful for Erica Navarre, who's helped us put together all of the logistics, technology-wise, and here in the room. Thanks to Chaiwood's DE&I committee and our professional development committee, who sort of helped kick off the thought that was this program, and a particular thanks to Mann and Burns, who's helping with all of the CLE credit that we all appreciate. And of course, a great thanks to the coalition. The national board helped bring all of this together. Two of our speakers come from our New York chapter, so we really are coming together in a number of ways to discuss this important topic. Most especially though, thank you very much to Grayson Moronta from Seyfarth, who's going to be our moderator today. She has probably done more work than anyone in trying to prepare for this program, and we appreciate all of it. So I am here to introduce her, and then she will introduce our panelists. So Grayson is an associate in Seyfarth Shaw's New York office, where her practice includes a broad base of traditional labor and employment litigation experience. Grayson's practice includes a strong focus on single plaintiff matters, where she represents employers in lawsuits on issues including discrimination, harassment, retaliation arising under both state and federal anti-discrimination laws. Described as a tenacious and inquisitive leader, Grayson is passionate about helping her clients build strong workplace cultures that center on diversity, equity, and inclusion. Grayson proactively assists her clients in mitigating employment issues by focusing her advice and counsel on best practices and solutions to personal issues, including how to maintain and manage a diverse workforce and helping clients develop and implement DEI initiatives and programs. Grayson is a graduate of Cardozo Law School, where she served in e-board positions on the school's Black Law Students Association and Minority Law Student Alliance. Grayson was also a member of Cardozo Law Review, where she served as chair of the Law Review's Equity and Inclusion Committee. Her passion for DE&I finds itself in her written work. She has published on topics including pay equality, pay transparency, and hair discrimination in the workplace. Outside of the law, Grayson enjoys experiencing the diversity of other cultures through travel and spending time with her family. And with that, Grayson, take it away.
Awesome. Hi, everyone. Thank you so much, Carolyn. It's a pleasure to be with you all this evening. I'm just so honored to be able to moderate such a important panel with such esteemed panelists, and I'm looking forward to a great conversation. With that said, I am going to advance the slides a little bit. There's a legal disclaimer there. Here is our agenda for this evening, our roadmap. We're gonna, as Carolyn mentioned, we'll leave some time at the end for Q&A, but these are just some of the topics that we are going to tackle. It is going to be a very just engaging discussion. I've met with all of the panelists separately and collectively, and I think that we are all in for a great, insightful treat this evening. So with that, I would love to introduce our wonderful panelists this evening. I'm going to start with my colleague, Tracee, who's a partner at Seyfarth in our New York office, where she's lead trial counsel in defending corporate clients against civil rights violations and advises clients across all industries on a range of complex matters, including ESG, data security, and risk and litigation avoidance. Tracee counsels C-suites and board directors on corporate governance matters, including strategic development, alignment, and design and implementation of ESG policies and practices. She serves as co-chair of Seyfarth's ESG Corporate Governance Group and co-leader of the New York office's Diversity and Inclusion Action Team. She is a past chair of the 2,000-member Commercial and Federal Litigation section of the New York State Bar Association, a group which laid much of the groundwork in establishing New York's commercial division, one of the first commercial courts in the country, and she served as the immediate past chair of the Judiciary Committee of the New York City Bar Association, which reviews the qualifications of all elected or appointed federal, state, and local judges sitting in the city of New York. She is also a member of the Association of Defense Trial Attorneys and the 2023 recipient of the Honorable Shira A. Schleidlin Award for Excellence in the Courtroom. Tracee's also a mentor of mine and just a wonderful, fantastic resource. So welcome, Tracee. Very, very excited to have you with us tonight. Moving on to our... Awesome. Moving on to our in-person panelists, we have Kim Metrick, who serves as the Vice President of Employment Law, Legal Operations, and Investigations for Walgreens Boots Alliance, a global pharmacy, retail, and healthcare company headquartered in Deerfield, Illinois. Fun fact, that was the first time that I learned that Walgreens was named Walgreens Boots Alliance. So very interesting to learn that when Kim sent over her bio. Since 1995, Kim has held various leadership positions throughout her career with Walgreens. In her current role, Kim is responsible for leading a team of employment law and benefits attorneys and legal staff engaged in a national employment and accessibility law practice. Kim also leads the legal operations function at Walgreens. Prior to joining Walgreens, Kim was an associate with the law firm of Ross and Hardy's in Chicago, and Kim currently serves as the executive sponsor of the legal department's Diversity, Equity, and Inclusion Committee. She has been recognized nationally for her commitment to advance diversity and was awarded the 2021 Woman of Achievement Award by the Anti-Defamation League in recognition of her efforts. Welcome, Kim. And last but certainly not least, we have Sonya Rosenberg. Sonya is a partner at Neal, Gerber, and Eisenberg LLP in Chicago, where she counsels employers on employee-related legal matters throughout the employment lifecycle. She is particularly adept at advising clients on developing and implementing anti-discrimination policies and helping establish DE&I initiatives and programs. Clients value that Sonya's ability to understand their needs and thoroughly assess their legal situations. Additionally, she actively contributes to the field through frequent presentations and has authored articles on topics such as employment law audits, risk management strategies, workplace harassment, and discrimination prevention, as well as biometric privacy concerns, social media, recruiting technology usage, as well as developments in labor and employment law. Welcome, Sonya.
Thank you.
Awesome. So moving along, I would like to take some time before we get into our panelist remarks to kind of just situate ourselves a little bit and really set the stage in understanding why we are having this important conversation today. So I think most everyone has heard about the fair admissions cases, but essentially what happened was in June of 2023, the Supreme Court released two companion decisions. One was a case that involved Harvard, a private institution, and the second was a case that involved the University of North Carolina. Essentially, both raised the same legal issues, but the Harvard case considered discrimination against Asian Asian Americans under Title VI of the Civil Rights Act of 1964. Again, Harvard is a private institution, and in their admissions decisions, they allowed race and ethnicity to be considered as part of a candidate's personal rating in their application. And the goal behind allowing race and ethnicity to be considered per the school was to prevent a dramatic drop-off in minority admissions compared to the prior class. That was their reasoning that they advised the court in why they allowed race and ethnicity to be a consideration in applicants' review. On the flip side of that, the UNC case involved white and Asian Americans under Title VI of the Equal Protection Clause, under Title VI as well as the Equal Protection Clause. UNC, on the other hand, is a public institution, which makes a little bit of a distinction for the purposes of the receipt of government funds. And in their admissions decisions, they allowed race and ethnicity to be considered as a plus factor in an overall holistic admissions process. The goal that they stated was to ensure that the minority enrollment percentage was not lower than the minority representation in North Carolina's general population. When these cases were being decided, both schools advanced the argument that the programs were consistent with Gerber, which was a 2003 Supreme Court decision that held that the Equal Protection Clause does not prohibit a school's narrowly tailored use of race at admissions to further a compelling interest. Race and ethnicity is just one plus factor in a holistic review and comprehensive admissions process, which up until this case was decided by the Supreme Court, what Harvard and UNC was doing and what they were considering in their decisions was consistent with Gerber. The lower courts agreed with this argument, but on appeal, when it got to the Supreme Court, they considered the issues of whether the racial classification used was to further those compelling interests, and whether the use of race is narrowly tailored to achieve this interest. I think we all know what happened because we wouldn't be having this conversation if it came out the other way. But the court overruled the lower court and essentially overruled earlier precedent and held that the policies that were advanced by these schools and the reasonings that were advanced by the school, which permitted the schools to consider an applicant's race, violated the Equal Protection Clause. So that is a little bit of background. That is essentially how we got here. And so per these decisions, per these fair admissions decisions, the use of race when making applicant admission decisions violates the Equal Protection Clause when looking at applicants for admissions to universities. But I want to kind of get into the idea of what this means in an employment context. And so I'm going to start with Sonya. What does this decision mean for employers? Are companies and law firms in legal jeopardy? You know, what should firms and companies start focusing on in terms of their DEI programs?
Thank you, Grayson. So the short answer to the question, and there is more to it, the Supreme Court decision really did not change the landscape when it comes to private employers' decisions in hiring, in promotions, in DEI initiatives. Because Grayson, to the points you were making earlier, this was a constitutional decision. There's no constitutional law in the private workplace. We're talking about Title VII of the Civil Rights Act of 1964, which has been around for a few decades now. We're talking about Section 1981. These laws have been in existence for many, many years. Nothing has changed under them. They do prohibit use of protected categories in the making of employment decisions, but it's a very different standard from the one that the Supreme Court applied in the SFFA decision. And the standard that exists in the employment context, I would argue, does not prohibit employers from continuing to implement thoughtful DEI initiatives.
And we'll get a little bit more into that, but for purposes of this initial question, I just want to point out that, many, well, I shouldn't say many, but a number of employers kind of ran to the hills or for the hills when the decision issued and started rethinking DEI initiatives at a time where I would say, it's very important for many to kind of double down on these initiatives, given what the statistics are showing. And the concern is that employers are receiving these letters, these threats of litigation, sometimes charges, sometimes even there's been a little bit of case law. But when you look at the actual legal standards and the law that applies, employers who continue to implement thoughtful DEI initiatives are on firm legal footing to do so. So we'll talk about that some more, but I want to point out the distinction, different standards.
Definitely. And so I think that it was probably really jarring for a lot of employers when this decision came down. And, they kind of immediately went into panic mode and were like, hey, how do we address this? But what I'm hearing from you, Sonya, is that essentially a lot of what was considered in, race or gender-based preferences in admissions, those are things that have long been unlawful in the employment context. And so essentially, if an employer had a DEI program in place before this decision, and it was lawful before the decision came down, it remains lawful today. Is that fair to say?
That's fair to say. Yeah, that's exactly right.
Okay. And so my follow-up question to that is essentially, how do we kind of balance the views of the EEOC on this topic, who have kind of come out conflicting, which, no surprise, it does come down to political party lines. And we've seen, some EEOC Democratic appointed commissioners coming out and supporting DEI initiatives, whereas Republican appointed have come out and kind of voiced opposition against it. And so how do employers kind of balance that inconsistency?
Yeah, so I would say there's been quite a lot of noise after the decision, and the slide that you put up, Grayson, I'm sure many of us in the room saw this exchange between Mark Cuban and the Republican appointed commissioner, Andrea Lucas. And to fill in the folks who maybe haven't seen this, he tweeted that race can be part of the equation when looking for people to put in his business in the best business position to succeed. And Andrea Lucas, who is one of the 2 Republican appointed commissioners out of 5 at the EEOC right now, said, "You're dead wrong on the black letter law. As a general rule, cannot be a motivating factor, cannot be a factor at all." And look, I think there is a lot of sort of noise about this, as I said, but nobody is really saying anything new in my view here. I mean, you are not supposed to base employment decisions on race. That has been the case for the longest time. Now, where we get into some gray area, and I would argue where employers do have some options with thoughtful DEI initiatives, is, for example, if you consider a diverse pool of candidates for the decision that you're making. You're not making the ultimate decision based on race or based on gender, but you're considering a diverse pool of applicants. I'm not aware of case law that makes that unlawful. And in fact, those of us who are in law firms know, and many of us subscribe to the Mansfield rule, which does exactly that. The idea is you strive to diversify the pool of applicants and then you make the decision. The ultimate decision is not based on race. So yeah, it's true that in making employment decisions, race, they shouldn't be made based on race or based on any other protected categories. Again, that has been the law for a long time, but it's much more, I would argue it's much more nuanced than that. That doesn't mean that you stop considering diverse candidates. That doesn't mean that you scrap your DEI initiatives. So they're both kind of, as I read this, to me, they're kind of ships passing in the night. They're talking past each other. In a way, they're both right, but the takeaway is, no, you can still have lawful DE&I initiatives. You can still do that. You should not be making your hiring decisions based on race, based on gender, sexual orientation, or any other protected category.
Yep, definitely. Okay, so Kim, I'd like to turn to you for your in-house perspective. So as we kind of mentioned earlier, since the fair admissions decisions came down, it's kind of just been, a state of panic for a lot of employers. But we've also seen just a lot of challenges come from conservative groups, such as the American Alliance for Equal Rights, who has either sued or has sent threatening letters to law firms demanding that they shutter their diversity fellowship programs. We've also seen state attorney generals who have sent letters to law firms, as well as just, lots of companies are now dealing with kind of backlash for their DEI programs. CEOs across the board have gotten letters as well. And so how have these developments changed your outside counsel hiring practices? What has Walgreens how has Walgreens sort of reacted to these decisions?
So it's a great question, and similar to how Sonya is approaching this from an employment perspective, we look at DE&I and accessibility as strategic business imperatives. This is something that we value to our core. It is a commitment that we have continued. We've had a long-standing commitment with respect to health equity, equity within our communities, in particular, thinking about all of the communities we serve throughout the country. So that is something that has not changed post-fair admissions. In fact, to your point, it highlights the importance of ensuring that we cast a wide net with respect to our outside law firms, also ensuring that our law firms share that philosophy with respect to commitment in DE&I, and there's a number of ways that we highlight that through our preferred provider program expectations. We weave this through our engagement letters, but also we recognize law firms that have really made an outside contribution with respect to DE&I. And Mansfield certification is just one of a number of organizations, Diversity Lab, NAMWOLF, that we partner with to ensure that we're casting a wide net and, ensuring that we're providing and valuing the diverse perspectives that you are able to really take advantage of when you engage a whole, host of different law firms.
Yeah, definitely. And I mean, it's great that the company, to Sonya's point earlier, has kind of doubled down and continues to, advance those DEI goals that were in place before the decisions came down. So that's really warm and refreshing to hear. I want to go back to you, Sonya, for a second to kind of discuss the law firm perspective. And so, I'm sure many people have seen this kind of floating around social media or legal news, but Senator Tom Cotton in July, after the fair admissions decisions came down, sent a letter to 51 major law firms detailing possible federal civil rights violations that he believed they and their clients may be violating with DEI programs. I remember seeing this. I remember, a bunch of my non-lawyer friends contacting me about it and being like, what's going on? What's happening? And I admit, it could definitely be a little scary. But what have those arguments that have been levied against law firms, like what have they been? What have been the responses to them from law firms? How do you see law firms kind of reacting to letters such as this?
Yeah, and I think you can even go back for a second to your prior slide because we have some responses on that side as well. So, first of all, when I read Senator Cotton's letter, it really, the devil is in the details, right? So you look at the letter and he says, law firm, just so you know, this decision was issued. Here's what the decision says without going into the nuances of the varying standards that we've talked about. And, law firms, you should know that federal law prohibits discrimination based on race and hiring practices, and we have serious concerns. You should evaluate what you're doing. So on a senator's letterhead, that looks pretty scary, I think, or can look pretty intimidating. And so, we saw sort of various reactions to these kinds of letters and these kinds of claims. Some law firms pretty successfully and pretty quickly changed some of the wording in their DEI initiatives or in their diversity fellowships, where instead of stating that the fellowship is targeting students of color or students from diverse backgrounds, the wording was changed to say that DE&I is an important value. We're looking for students with interest in promoting that value. So that kind of rephrasing caused some of these organizations to drop claims and to leave these law firms alone. And then, some absolutely, our law firm included, and I'm proud of that, we've stayed firm on our DE&I commitment and our DE&I related initiatives. Other firms just scrapped their initiatives altogether when they saw that come through. So the whole range is there, and it's up to law firms and organizations to decide what to do. I just want to make sure that, one of the thoughts and one of the interests I have in doing this program is I think there is quite a bit of misinformation out there as to what is actually legal and what isn't. And these things can seem scary, but when you sort of dig a little bit deeper and see what the law is and what it has been, and you recognize the fact that it really has not changed.
Yeah.
Employers are okay to keep doing the good things that they're doing and that they frankly really need to do right now in that space, because we'll talk about the statistics and the numbers. And while there's been some progress in some areas, they continue to look devastating in many areas. So this is not the time to say we've figured it out and let's not worry about DE&I anymore. This is the time to be more proactive, more thoughtful, and more committed to that cause, I would say.
Definitely. Very well said. Which you mentioned statistics, and this actually brings me to a great point that I would like to raise to Tracee. So Tracee, you do a lot of work in the ESG space. You do a lot of counseling for C-suites and boards. And, as Sonya mentioned, the statistics are kind of grim. And they show that both the legal industry and corporate America have struggled to diversify their workforces and upper ranks. So what considerations should boards and C-suite individuals take into account when considering DEI initiatives?
It's not just a nice thing to do, but I think, as was mentioned earlier, it is a strategic business imperative, not just for healthcare participants, but for every industry out there. Statistics time and time again have established the importance of having a diverse workforce, of making certain that organizations that make a commitment to diversity honor that commitment to diversity. In the ESG space, what is so compelling about what's happening right now is that despite the backlash that ESG itself is experiencing, for those of you who do or don't know a little bit about ESG, E stands for environment, S stands for social, and G stands for governance. within each of those bucketed areas, which are traditionally viewed as non-economic factors, non-economic drivers. It's the market views them now as quantifiable intangibles. So goals around how businesses operate to those intangible factors such that they can create a sustainable ongoing operation. Those factors are viewed, and not just in a summarial fashion, but in a way where each one of those aspects, of course, which under social includes human capital, which includes DE&I, which also looks to pay equity, and it attempts to create a framework of what optimization of those various factors in operating within each discrete industry means, and what steps can be taken to further advance those objectives. And I just recently finished recording a podcast episode with my colleague who specializes in executive compensation, along with a partner over at KPMG, where we talked about how now executive compensation is being tied to those benchmarks, whether or not those goals and objectives are actively being pursued and met. And it's not just based upon a feel-good exercise. It's based upon looking for financial quality-like data, verifiable data that these benchmarks and metrics are being measured. So if we're talking about diversity and inclusion, it's now more than ever, the market is demanding businesses be transparent about how much they're doing and what efforts they're undertaking in meeting their diversity and inclusion commitments. For any publicly listed company, the SEC requires a human capital disclosure report. I can tell you that Seyfarth has put together a report of what it found in reviewing the K-10s of 20 companies across various industries. And in each and every instance, 80 some odd% of those surveyed said that not only culture of their institution is of utmost concern, but DEI initiatives as well as pay equity. So with any area where the market has access to information about the internal operations of a business, the various stakeholders, whether it be the shareholders, whether it's employees, whether it's prospective employees, they're all going to rely and look at that data to see exactly what that company's commitment is to DE&I. And if there's a disconnect, that's when the litigation aspect of my background kicks in. We'll talk about it a little bit later, but it's imperative. It's a business imperative that businesses continue to look and analyze their ongoing DEI initiatives, to double down on those initiatives, because where there's numbers, where there's benchmarks that are established, there are also rating and ranking agencies out here who are tethering business activity, what they of where the company lands vis-a-vis its competitors. And if you have a competitive advantage in that space, it is going to make every difference in the world. Whether you're a preferred provider, whether you're, a third-party vendor, whether you, are looking to investors to invest, these numbers make a difference. And we'll talk a little bit later, I hope, about why.
Definitely. Kind of on that same note, I know that a lot of companies do have, or have maybe in the past had quota systems, and have received challenges to their quotas. So Kim, going back to you, it is commonly accepted that in order to change something, you must measure it. How do you balance efforts to measure the effectiveness of DE&I policies against challenges of quotas? And understandably, quotas are not permissible under law, but how do you kind of teeter that balance between DE&I and quota systems?
Yeah, that's a great question. And, it's something that, as a company, you really do need to have a clear strategy and, goals that are aligned to, labor economists and science to really ensure that they are, clearly able to be measured. But at the same time, you also want to be very sensitive to how that is communicated amongst your leadership team. There is an educational opportunity with respect to not, we know that quotas are not permissible. We know that Title VII, as Sonya mentioned earlier, would prohibit employers or managers from taking actions based on race, gender, or any protected characteristics. But you also know that there are a number of levers that can be pulled, when you really get down and analyze your workforce and analyze certain trends that you're seeing. So you always kind of need to have to put on, I always say you put on your Dr. Diversity hat and you really kind of look to see, okay, is this a hiring issue? Is this a retention issue? Are we seeing a disproportionate number of people leave the organization? And if so, why is that happening? So it's just not an easy, it really does take a commitment to care and ensure that we're being very thoughtful in terms of how we analyze our workforce, but also not send a message that there's an expectation that this is a straight numbers game, because it's actually not. It's highly complex space, and I do feel like the educational component cannot be understated. Like the need to really work to partner with your managers at every level of the organization to, get very comfortable with this conversation, because it's not going away, and but yet it's something that really does take a level of commitment and education to make sure that this is executed in a way that reflects your company values, but also is consistent with law.
Definitely. So last week, actually, when I was preparing for this discussion, I saw that the 11th Circuit issued an opinion blocking the enforcement of Florida's anti-woke law, which is very interesting, just considering the composition of the 11th Circuit and how, conservative leaning they usually are. But essentially, the court struck down the law on the grounds that the law impermissibly infringes on employers' free speech rights by limiting the concepts that employers can espouse in mandatory corporate DEI training. So going back to you, Tracee, from an ESG perspective, how can companies balance decisions such as this one, knowing that challenges will only continue in the wake of the fair admissions cases?
Well, I really appreciate that question, because I'm very much involved in the New York State Bar Association, as you know, and they assembled a dynamic group of distinguished thought leaders within the legal community that some concrete suggestions for this and how they could go about addressing the backlash that presently exists. And I think that Kim brought up one critical point, and that is in educating not only leadership, but educating and making that a part of the overall corporate culture. And that's one way where ESG, I think, certainly brings a balance to that, the backlash that exists. Just like the DEI conversation is not going anywhere, ESG is not going anywhere. The data, the more the data is available, the more the data is going to be collected, the more the information that is collected will go towards the countless studies that do in fact exist that substantiate the business case for diversity. So I mentioned in response to my prior to the prior question that why is it not going anywhere? Why are we having this conversation? Well, I think in just not only looking at the likes of McKinsey and Company, who has historically issued report after report with the transparency of and availability of data that will continue to only increase as more and more stakeholders demand more information on what's actually happening in the DEI space. The business case showing that diverse teams produce greater outcomes, that diverse healthcare providers realize greater outcomes for patients, that provide countless enhancements in the profitability, efficiency, risk management aspect of any business operation, that it's not going to stop. And why I was uplifted by the 11th Circuit's decision is because the one thing that the American Alliance and the rest can't do is they can't stop the conversations from happening. The tough conversations from happening. They can't stop the the disclosures and the measurement and the interest in trying to create a corporate environment where it looks at ways to minimize and eliminate biases. Definitely. So where's the counterbalance? I think what ESG does, particularly in this space, is it gives a quantifiable way to assess a situation that previously really wasn't accessible. And I think that given the 11th Circuit's recognition that not only can corporations not be precluded from discussing these sensitive topics, but encouraging a collective discussion within a corporation, within the community, to continue to have these kinds of conversations is where advancement, I think, will certainly help to be made.
Definitely, definitely. Okay, that's very helpful. And we'll definitely get into that point a little bit more when we get to sort of, what can companies and law firms be doing now. But I want to go back to the Mansfield rule. I know we've kind of talked about it a little bit, but for those who don't know, the Mansfield rule, which is named after Arabella Mansfield, who was the first female lawyer in the U.S., is inspired by NFL's Rooney Rule and it essentially asks law firms to consider at least 30% of historically underrepresented lawyers for promotional/leadership opportunities. This has become something that a lot of law firms have started to follow. More than 240 US and Canadian law firms achieved Mansfield certification in 2023, and 100% of existing firms have opted to renew their commitment for 2024. So going to you, Sonya, I would like to talk to you about the Mansfield rule because there's recently been some challenges to it, some developments to it with the NFL and Disney. And so particularly in light of these recent developments, and if you could give us just like a quick background on them, do you think that the Mansfield rule may be on thin ice?
Yeah. So the short answer to the question, legally speaking, I think the Mansfield rule remains on firm footing, and I think that's pretty well demonstrated by the fact that law firms who are quite risk averse, as we know, all 240 of them that were previously signed on to Mansfield rule before the SFFA decision came out, gladly renewed their commitment to the Mansfield rule again this year following the decision. So I think that says something. I think that's quite a compelling point. There's been some noise again. So AFL wrote to the EEOC contending that the Rooney rule that the NFL follows is unlawful. There was also a charge filed against Disney saying that their practices where, you know, that's an interesting one, and I want to see how that develops because they do put some percentages in terms of these are, you know, how many people we'd like to see in these categories. But again, you know, query whether there is any actual substance to the challenge, but it's been filed. So we've been seeing this in the news. I do think the Mansfield rule is on firm footing because, again, it strives to diversify the applicant pool. And then the ultimate decision is not a decision made on protected categories. And the thing is, the Mansfield rule has actually been really important in helping many law firms diversify their attorney ranks. We saw that within our own firm. You know, our executive committee is now more than 40% comprised of women and diverse attorneys. So we're seeing differences when you put DE&I top of mind to the decision makers, which is basically what this does. It requires you to think more broadly and to consider diverse applicants and diverse candidates for promotion. You're more likely to make the right decisions because it's top of mind for you. And I'm actually now involved in Diversity Lab's hackathon, which they brought back, and that has been a really fun process through which you look at really interesting materials and you partner up with teams to think through smart, effective DEI initiatives. And I've been really enjoying doing it this year, and seeing the energy behind it has been really inspiring, and I don't see that going away. And again, the other thing that this discussion makes me think about, I think we sometimes forget that the laws that were passed in this space, when they were passed, like, what was the purpose of them? They were not intended to protect the older white males in staying in positions in power. That is not why Title VII of the Civil Rights Act of 1964 was passed. That wasn't the point. The point was to address very serious issues of inequity and of racism in this country. So, you know, have I seen reverse discrimination cases in my practice? Yeah, they've cropped up every once in a while. You know, I've been working in the employment space for more than 20 years, most of them as an attorney. Do I see many successful reverse discrimination claims brought by white males? Not so much. It's not, you know, really something that, is very compelling, generally speaking. And the kinds of things that you were talking about, Kim, looking thoughtfully and measuring data as to how companies are doing in the space and law firms are doing in the space, I am more so concerned about sort of adverse impact scenarios that can happen, and this is something that the hackathon is talking about, for example, in promotional and in evaluation context, where seemingly neutral, well-meaning comments and points of feedback end up disproportionately negatively affecting people of color or women or people, who are gay or queer. So I think, it's important to remember sort of how did we get here? Why were these laws passed in the first place? And hopefully that helps kind of law firms and organizations feel a little bit more bullish about staying firm on these efforts.
Definitely. And that's very helpful. Okay, so it looks like we're coming up on that 5-minute mark soon. So I want to pose a question to all of the panelists today. Generally, what suggestions do you all have for law firms or companies that want to remain committed to DEI in the face of these challenges that have come from cases such as the fair admissions cases, as well as, from conservative and Republican senators and groups? And I will start with you, Kim.
So my suggestion is that we, stay the course. We are always mindful of the ever-evolving legal landscape, and as an employment lawyer myself, it's actually can be very inspiring just to be able to be the calm voice in the room and just to help to kind of demystify some of the noise that's out there on this topic. So I encourage you all to kind of educate yourselves on just this very evolving topic, and the law is just literally changing as, by the day, and not necessarily the law, but the application of some of the themes that we've been talking about today to real life scenarios. So, really helping to educate your leadership team. It's so important to ensure that we have a very, thoughtful approach with respect to DE&I. It's a very holistic approach. It's not just about numbers. It's really about ensuring that we have, from the onboarding to, the exit, a very, that DE&I, the strategies that we've just discussed are woven into the business framework, and also, ensuring that we're staying on top of this, that we're not putting our heads in the sand, and but being very, proactive. It's certainly a healthy time to look at your training, look at your policies, make sure that you're aligning them with DEI best practices, but stay the course and just really kind of be there to support your teams in this ever-changing environment.
Definitely. Yep. What about you, Tracee? What do you have to add?
I'm always encouraged by the increase in analysis and data that is now put in place to back up much of what has traditionally been just an amorphous conversation that wasn't necessarily grounded in fact. I think the more data analytics are employed in this space and looking at pay equity and looking at, the kinds of assignments, if we're talking about internal to firms, opportunities for advancement, career development, evaluations, if all of these areas are quantified in an objective way, I think that we'll have the kind of framework where we can do the comparative analysis year over year rather than to rely on less objective measurements. And I think with that, it will provide yet one more effective tool in helping to ensure that companies do look to advance their DEI initiatives rather than to, look at them as just a nice thing to have rather than a business imperative. That truly, I mean, for some businesses, it's a C-suite board issue. And I think that with the changing demographics, younger employees expecting diversity in the workplace, alignment of values with the institutions that they work for, investors recognizing the financial upside to increase diversity. I think that we'll see more and more of an analytical approach to making certain that the DEI objectives and goals are top of mind, and true accountability is applied in making certain that advancements are made.
Okay, definitely. And then last remarks from you, Sonya, before we get into some questions.
Yeah, sure. I really like the comments that have been made by Kim and Tracee. I think staying the course, being analytical, I completely agree with that. And I would just echo that and add one more thing. I think working initiatives in that space, which as we've discussed, absolutely can be lawful and absolutely should be implemented. Working initiatives in that space, they're nuanced. They have to be thoughtful. They have to be strategic. It's not enough to hire, a DEI officer for the company and the law firm without any support for that person and expect that, oh, now we've solved our DE&I issue. We're good now. It's not enough to say, oh, okay, well, we subscribe to the Mansfield rule, so I guess that we're done. It takes a whole lot of work. It takes a whole lot of strategic planning and real thought and commitment at all levels of the organization to actually move the needle in this area. So yes, stay the course, yes, be analytical, and please be thoughtful and strategic about it, and stay with it in a thoughtful and strategic way so that you can actually see success instead of, turnover and additional issues in the area.
Awesome. Thank you. Okay, so we have a few questions virtually and possibly in person. So I'm going to start here. So Sonya mentioned anecdotally that you've seen reverse discrimination claims creep up. Is there any information or stats about a plaintiff's success rate, whether or not that success rate has increased following the fair admissions cases?
That's a really great question. I don't have an answer to that offhand. Would I be surprised if there was some slight uptick, at least in the filing of those? Certainly there's been an uptick in the filing of these kinds of cases. In terms of their success rate, what I think I can tell you with some confidence is that compared to your classic discrimination cases, the success rate of reverse discrimination cases is going to be incomparably lower. Yeah. I think that's fair to say. Whether there's been some increase, in the past few months, I would expect that there's probably been some more movement in that area. But generally speaking, just based on my experience in the area, those cases don't tend to be as successful as the ones brought by people of color, as the ones brought by individuals from actually underrepresented categories. Because again, that's who these laws were intentioned to protect.
Yeah, definitely. And I can confirm, so our firm does a bit of tracking of the cases that are filed in this space. There was definitely an uptick even before the decision came down. But since the decision has come down, there's definitely been a lot more challenges nationwide, even, you know, in places that you would consider more liberal leaning, so like New York, California. There's still been some challenges to just all different types of policies and hiring practices for companies across the country. So thank you, Sonya. Next question is, what does the data look at to quantify the impact of DEI on a business or school community? And I think that's a great question for you, Tracee.
So it's interesting because Bloomberg just recently let for public consumption a DEI framework that they will help you to bucket your data so that they can provide you an objective sense of where your program lies. And some of the factors that are included is not just hiring. Of course, it's also retention. It's the cultural environment within which belonging and inclusion is measured. It's fascinating because they look at pipeline, what initiatives are in place for pipeline, what opportunities are for leadership roles and advancement, strategic and business strategies and innovation in looking on each one of those areas, whether it's in hiring, whether it's in retention, whether it's in career advancement or career development. It also looks at the marketing of diversity and inclusion. That too is one area that's assessed. So I say these areas generally, but you know, when it comes to looking at data and implementing a framework of analysis, it is critically important that each individual industry, each individual company's objectives and goals are assessed to see exactly what's driving the company's profitability and where DE&I fit into driving that profitability. So it's not done in a vacuum. The buckets may change based upon where the company is in its growth trajectory. So it's not a check the box exercise. It is one that does require thought, care, and analysis. But it is possible, given that I've just listed, and just like Bloomberg is able to identify some discrete areas of critical importance. And it is those areas of critical importance where the data and the analysis will become critically important. And what I find fascinating about ESG is that most oftentimes you'll find that businesses do their own disclosures based upon industry-wide practices, right? There is no law that says you've got to disclose what kind of DE&I initiatives you have underway. But where those disclosures are made, where an industry standard has been set, what's interesting about ESG is that it brings together an industry-wide standard, a coalescence around various factors that are going to be deemed critical, quantifiable areas that is established based upon data will impact the overall profitability and risk avoidance. of businesses in that industry. So it is through careful analysis. It's knowing what your industry you're in and what drives your bottom line, and making certain that it's tailored to provide the kind of thoughtful analysis and data to make certain that what you're saying is aligned with exactly what's going on within your organization.
Thank you. All right, I'm going to pass it over to Carolyn now, who will see if there's any in-person questions before we release you all to go enjoy some drinks and some hors d'oeuvres.
Thanks, Grayson. I know we're just a touch over, but if we have any questions in the room, I can come and we can answer your questions. Do we have any questions here? Any brave souls who want to ask a question? All right, just 1 second.
I do have a question about like a hiring policy that's a little bit different than the Mansfield rule. So a lot of law firm employers engage in, law student hiring where they participate in diversity programs, where there's a diversity organization and they open the application process up to diverse applicants. And, within the law firm, they do their standard 1L or 2L, open on-campus interviews, but then oftentimes they reserve, 1 or 2 spots for participation in those diversity, hiring programs. Now, does that program, because the pool is exclusively of diverse candidate applicants, how does that stand up to, challenges?
I can chime in on this one a little bit, and then I'm sure Kim can as well. So there's absolutely nothing wrong, and it's good practice, highly encouraged for law firms to check out various student organizations, including student organizations and affinity groups that attract students of color, LGBTQ students, whatever it is. I mean, there are a number of them in Chicago. There's nothing wrong, and it's great for law firms to check out those programs, to meet with those students, and to bring those students back for interviews and potentially to make offers to those students. In your question, the one comment that gave me a little bit of pause is if the firm then says, well, we're going to save 1 spot for a student of color. I would say don't do that. Hire your qualified applicants. Would it be so terrible if you end up, actually, as we did this year and last year, with 75% of your summer class being women and or diverse attorneys? That would not be a terrible thing. Again, let's look at law firms and the statistics that we looked at. We need to make so much more progress. So I would say, great to get to know these organizations, to recruit students from these organizations, and maybe to go back to the comment about being careful about not having these sort of, well, we have 1 spot for a student of color. Don't do that. Hire, however many qualified applicants you get, regardless of color ultimately.
Yeah, I would totally agree.
Awesome.
Any other questions? All right, well, I can't thank you guys enough. It has been an absolute pleasure to work with some old friends, Sonya and Kim, and make some new friends, Grayson and Tracee, and to see so many people here, both old and new friends. So I know we all could continue this conversation for a very long time, but I encourage all of you who are here to do so over some nice drinks and bites and make some new friends from the Coalition and Chai Whip. Thanks, everybody.